Pardon? No, no gavel this time. Okay. All rise. The North Carolina Court of Appeals is back in session.
All right, be seated, everybody. Thank you. Well, we got some new faces at council table, and welcome back to the North Carolina Court of Appeals. We're glad to have everybody in person. If there are no preliminary matters, we'll hear our second case on the calendar, which is case number COA20-564, State v. Johnson, and we'll hear from the appellant.
Good morning.
Good morning.
May it please the court, counsel. I am Assistant Appellate Defender Michelle Goldman, and I represent Mr. Johnson in this appeal. I would like to reserve 5 minutes for rebuttal.
Thank you.
Today, on the one-year anniversary of George Floyd's murder, this court is asked to address an issue that will have a tremendous impact on the lived experience of North Carolina drivers, disproportionately affecting young black men like Mr. Johnson. Mr. Johnson asks this court to reaffirm State v. Parker and hold that an officer who asks for consent to search during an ordinary traffic stop without any suspicion of criminal activity prolongs the stop and violates both the United States and North Carolina constitutions. Lieutenant Stone stopped Mr. Johnson in broad daylight for briefly driving on a public road without fastening his seatbelt. Stone articulated no other reason for the stop. Mr. Johnson was entirely cooperative, providing his driver's license when requested. Almost immediately, Lieutenant Stone detoured from the lawful scope of the traffic stop.
Well, is it really a detour from the traffic stop, or had in fact the officer indicated he was giving a warning for the seatbelt infraction at that point?
He didn't indicate that he was giving a warning, but he hadn't done the ordinary and customary things associated with the traffic stop, which is running driver's license and registration and potentially doing a warrants check, those things. So the stop at that point wasn't complete.
Does he have to do those things?
I'm sorry?
Does he have to do those things as part of a traffic stop?
He doesn't have to, but he did indicate to Mr. Johnson that he, if everything checked out, he would be just getting a warning. He didn't actually say, I'm just giving you a warning for the seatbelt violation. So he did have the authority to go ahead and do those other activities, but he had to do them expeditiously under the case law, and he didn't do that here. When he asked Mr. Johnson if he had anything illegal on him, that was his first step on a detour away from the traffic stop mission. He took a second step when, after Mr. Johnson denied having anything on him, he asked for consent to search. His third step on the detour was actually conducting the search, and that step took him approximately 26 seconds, and he probed the depths of Mr. Johnson's pocket during that time. I will address why this warrantless search violated Mr. Johnson's constitutional rights in 3 ways, but I will do so in a slightly different order than they were briefed. I intend to first address how Stone's detour from the traffic stop mission impermissibly added time to the stop and thereby rendered any consent Mr. Johnson gave involuntary as a matter of law under the Fourth Amendment. Second, I will talk about why even without the added time, even if it added no time to the stop, this court should hold that asking for consent during an ordinary traffic stop without reasonable suspicion violates the North Carolina Constitution's prohibition against general warrants. And finally, I'll address why Stone's probing search exceeded the scope of any reasonably understood consent that Mr. Johnson gave. First, turning to the Fourth Amendment argument. Stone's request for consent to search and his intrusive search of Mr. Johnson's pockets was unrelated to the traffic stop mission and it added time to the stop. Stone had no reason to request or conduct the search other than it's what he does in every traffic stop he conducts. This is his modus operandi of conducting traffic stops. The search added time to the stop and it rendered the seizure unconstitutional. Any consent he obtained during the unlawful seizure is involuntary as a matter of law.
At what point do you contend the seizure became unlawful in this case? Was it the moment that Mr. Johnson was asked to get out of the car?
No, Your Honor. Under Pennsylvania versus Mims, the officer had authority to ask Mr. Johnson to get out of the car without any reasonable suspicion. He could do that. When he asked Mr. Johnson whether he had anything illegal on him, that had nothing to do with processing a seatbelt violation or a seatbelt infraction. And so at that moment, he took one step off the road he was supposed to stay on. He took another step when he asked to confirm that Mr. Johnson didn't have anything illegal on him by conducting a full search. And the search then continued down that same path. This state in its brief seems to argue that by getting consent, it authorized this detour, and that simply cannot be true. The case law is clear from the U.S. Supreme Court and our courts that the officer must expeditiously process the object of the traffic stop, and asking for consent to something totally unrelated to the traffic stop purpose cannot justify the departure. So that addresses some of the rules that must be applied here, which come initially from Terry versus Ohio, which says that investigative detentions, which traffic stops are a species of, can last no longer than is necessary to address the purpose of the stop. They must be carefully tailored to their justification, and officers must use the least intrusive means to complete the traffic stop's purpose. As I mentioned, there are legitimate activities that officers can conduct while they're on that appropriate path. They include checking driver's licenses and registrations, running warrant checks, those sort of things. But as this court said in Duncan, State versus Duncan, which is cited in Mr. Johnson's brief, they don't include full searches.
So you're saying it's activity versus a time analysis? Because it would take longer, presumably, to run warrants check, take everything back to the car, versus a quick consent search.
That's correct. The consent search actually had nothing to do with running a warrants check. It had nothing to do with those permissible activities. Now, if he had asked Mr. Johnson, is your license valid? Do you have any warrants? And Mr. Johnson had said no, and he said, okay, well, that answers those questions. I don't need to run it. I think that would have been fine. But under Rodriguez versus the United States, officers can't engage in alternate investigations without reasonable suspicion to support them.
Doesn't consent negate the reasonable, or we're talking about two different things. You have the constitutional provisions that are admittedly narrowed by Terry versus Ohio and the other cases. But on the consent search, that's a totally different realm, and you don't have those same restrictions. And that's kind of, as I view this case, the differentiation between the parties. The state says it's consent, we can go as far as we want to, and Mr. Johnson is saying that it wasn't consent.
Yes, Mr. Johnson's saying two things. One, he acknowledged when he testified at the hearing, he did give consent, but his reasonable understanding of the consent he gave was to a much more limited search, which would have been a pat-down for weapons, which would be what somebody would expect to be subjected to in the context of a traffic stop for a seatbelt violation. However, his additional argument is that by asking for consent, Lieutenant Stone detoured from the traffic stop mission, and that made the seizure unreasonable. And Rodriguez versus United States clearly says that. If an officer goes down a different path and it adds time to the stop becomes unlawful, and our case law is clear that a consent given during an unlawful seizure is involuntary and cannot justify a search. So you can look at the consent to see if it was, coerced or if it was within the scope and all of that. But before you even get to that point, you have to ask whether or not consent was given during a lawful seizure. Because if it wasn't, it's involuntary as a matter of law, and the state has not met its burden of showing the voluntariness of the consent it seeks to rely upon.
I think one of the interesting facts of this case is that, this appears to be, watching the dash cam video, clearly a search for contraband. This was not a search for weapons. There was no pat down, which then perhaps led to a further search, as in Duncan.
Right.
There's, the officer approaches the suspect from the front and immediately puts hands into first the pocket on the sweater or the hoodie, and then down into the pants pockets.
Correct.
And so how do, within the context of that, how do we view those actions within your analysis, that this was clearly a search for contraband, not a search for weapons or some other illegal item?
Well, I have two parts to my answer to that question. The first is, I think as an initial matter, the court needs to assess the legitimacy of the consent, the voluntariness of the consent, because the state is seeking to justify this warrantless search by using consent. And that question looks at the seizure and whether it stayed within its constitutional bounds. And I think it's pretty clear under State versus Parker and State Rodriguez that it did not, and that any consent Mr. Johnson gave was involuntary as a matter of law. Then I think the court's question about what do we make of this intrusive search, I think you have to look at, that raises the issue of the appropriate scope of consent that Mr. Johnson gave. And Mr. Johnson testified that he understood the scope of his consent to be limited to a pat-down search. And in his trial counsel's argument to the court, she said that's what a reasonable person would have understood in this context. The trial court really sort of didn't answer the question of scope. The trial court simply said Lieutenant Stone asked for consent and Mr. Johnson gave consent, and then kind of punted on the objective question of what a reasonable person would have interpreted that consent to be by saying, even if it had been just a pat-down, even if his consent was only for a pat-down, plain feel would have authorized the seizure of the contraband. Well, that just doesn't work. Under Rodriguez, again, the court said we don't look at what an officer could have or might have done. We look at what they actually did to determine the constitutionality of the search or the seizure. And in this case, the search, as Your Honor has pointed out, was intrusive from the get-go. Lieutenant Stone didn't feel a thing until he stuck his hand into Mr. Johnson's pocket. And so Lieutenant Stone needed to have a constitutionally adequate basis for doing that. And if Mr. Stone's reasonably understood consent didn't include that intrusive of a search, plain feel cannot justify it.
Plain feel or plain view is an extension of the search based on probable cause, but an exception to the warrant requirement. So if you want to talk about whether probable cause existed at that point in time a little bit, in the context of this case, it may be helpful.
Okay. I would say certainly there was no probable cause to do anything to search prior to Lieutenant Stone putting his hand in Mr. Johnson's pocket. The state didn't argue that there was, either in the trial court or on appeal. This was, by all accounts, a very ordinary stop for a very minor traffic infraction. Mr. Johnson was not even on the road for very long before he was pulled over. Lieutenant Stone did not articulate anything, any basis for conducting a search. In fact, he candidly testified that he just does this as a matter of course in every traffic stop.
The testimony seemed to indicate that when Lieutenant Stone was testifying from the transcript, that in essence what he was doing was searching for weapons. He was performing a Terry frisk based on the testimony in the transcript. It appears as though that's what he intended to do, although he indicated at some point that he asked to search, not to frisk. So, but when asked about the search itself, he articulated that in terms of a Terry-type frisk.
He articulated what he was looking for. He said he was looking for weapons, but he was very clear that he preferred to do a full search, that he didn't ask for consent for a frisk unless he was denied his request to conduct just a search. He left his request, I think, purposefully ambiguous because he said he was very clear on how he does this. He asks for this generalized consent, and if he can't get that, then he narrows it to a frisk, which would have been for weapons.
Thank you.
I'd like to turn briefly to Mr. Johnson's argument that should this court accept the state's claim that this request for consent didn't impermissibly extend the duration of the stop, I would ask this court to look at Mr. Johnson's claim under the North Carolina state constitution and to hold that under our constitution, which prohibits general warrants, that any departure from the scope of a traffic stop, whether it adds time or not, violates the prohibition against general warrants. In 1968, Terry promised that investigative detentions and pat-down searches would be limited in scope and duration. In 1983, Florida versus Royer reaffirmed those dual limits on investigative detentions. And that was how it was until 2005, when in Illinois versus Caballes, the U.S. Supreme Court diluted the scope and duration protections by collapsing them into a single inquiry. After Caballes, the multitasking officer could exceed a traffic stop scope with impunity as long as he did not thereby increase the duration of the stop. The weakening of the Fourth Amendment protection has led many in our society to be subjected to roadside fishing expeditions, where officers try to find evidence of other wrongdoing while simultaneously running warrant checks and writing citations. Sometimes in a case like this case, an officer doesn't even try to multitask and simply sets off on an unrelated investigation by asking for consent to search. These fishing expeditions disproportionately affect people of color, especially young black men. At best, these unsupported investigations are an assault on the dignity of the detained person, and at times their consequences are even much worse.
So on sort of the state constitution versus, Fourth Amendment and federal constitution analysis, sort of a couple of things that come to my mind is we have case law that says that basically the two provide identical protections. So, you know, so I guess A, how much daylight is there between the two? And B, in light of the authority that says they're essentially identical protections, does this court, as an intermediate state appellate court, what authority do we have to create that daylight independently?
I think this court has not only authority but an obligation to look at the protections the North Carolina Constitution affords, or that, and the North Carolina Supreme Court has said that our Constitution is to be liberally interpreted to protect liberty and security of North Carolinians in respect to both persons and property. Our Supreme Court found that daylight in State versus Carter. And while it is true that our Constitution has been interpreted in line with the U.S. Constitution on Fourth Amendment issues in a majority of cases, that doesn't mean that they are identical. And our courts have recognized that where appropriate, there needs to be a separate analysis. And I would argue to this court that where the U.S. Supreme Court has collapsed the protections of the Fourth Amendment or has diluted the protections of the Fourth Amendment by collapsing the scope and duration requirements promised by Terry, this court should reconsider whether in this context the North Carolina Constitution's prohibition against general warrants affords our citizens more protection. And I think it should. And the court, you know, just as it did in Carter, the North Carolina Supreme Court looked at this evolution of Fourth Amendment jurisprudence in the federal context. Wait a second. To afford greater protections under the North Carolina Constitution. Here, the traffic code is traffic is so intensely regulated that an officer can pretty much find a reason to stop anyone, anytime he wants. If during that traffic stop, an officer can pursue an investigation without reasonable suspicion, as long as he doesn't add time to the stop, the traffic code itself becomes a de facto general warrant and violates our Constitution. Mr. Johnson is simply asking this court to reinvigorate the dual inquiry that Terry and Florida versus Royer articulated and hold that traffic stops must remain within the scope of their intended purpose. Finally, I will address the scope of Mr. Johnson's consent. If this court holds against Mr. Johnson on the Fourth Amendment and state constitutional arguments, it will then have to reach the argument raised about the scope of Mr. Johnson's consent. And the test is clear. It is an objective test. The courts look at what would a reasonable person have understood in the context of in the exchange between the officer and the person, in this case, Mr. Johnson. In a traffic stop context, an unspecified request to search would reasonably be understood to be a request for a pat-down. Terry's been around since 1968, and it's allowed pat-downs where appropriate. The pat-down is a commonly understood tool for law enforcement officers to mitigate any risk that might exist. To be valid, Mr. Johnson's consent had to be unequivocal and specific. Stone's request to Mr. Johnson was vague and ambiguous and could not support a finding that Mr. Johnson gave unequivocal and specific consent to the search that was conducted.
So, do you concede that he could have said no to the search at any time, Mr. Johnson, the defendant? He could have said no?
He could have said no, yes, but that, I don't believe, answers the question. I think that his reaction to the scope of the search is a factor that the court can consider, but given that this is an objective test, putting too much reliance on that factor converts it into a subjective test.
And he could have limited the search as well. You can see that to what the officer could do. He could have said, yeah, you can search
Yeah,
my pocket, or you can search my car, or you can search nothing.
he agreed to the search, and I think the question is, under the objective test, what would a reasonable person have understood to have agreed to? So, yes, there are other possible ways he could have responded, but I think this court needs to look at his response and analyze it from an objective person's standpoint.
And if it had gone too far, he could have rescinded it. Is that correct?
He had the option to rescind it, and I think that is the factor that the state has made the most of in this totality of the circumstances analysis. And I think it's important for the court to bear in mind that this is an objective.
Where do you get that totality of the circumstances analysis from the record in this case? I know what the case law says, but from the record in this case, where do you get that standard of analysis?
Well, I think it's the legal standard that's applied, and then the court should look at
I understand what the case law says. I'm asking about the record in this case.
whether or not that, I'm just trying to understand the court's question.
I didn't see anywhere in the record where the court said that it was applying the totality of the circumstances analysis.
No, I think that the trial court did not, never did address the scope issue that was clearly raised. And, the court, as I said earlier, merely said Stone asked for consent, Mr. Johnson consented. The court never determined how a reasonable person would have understood the scope of the consent given. And I think if the court gets to that issue and doesn't feel like it can answer that question from this record, then this court can remand for further findings. But I would urge the court to find for Mr. Johnson on the much clearer issue of the Fourth Amendment violation, and if necessary, the North Carolina constitutional violation.
And you are into your rebuttal time, but
I'll-
I'll give you a few extra seconds because of sirens, but.
Okay. In Schneckhoff versus Bustamante, the United States Supreme Court cautioned, and I quote, "It is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon." Mr. Johnson asked this court to be watchful of his rights, and in so doing, protect the rights of countless others who are subjected to the daily indignities of traffic stops that are used to further suspicionless criminal investigations. As we have seen all too often, these unsupported forays are dangerous to liberty and indeed to life itself. Mr. Johnson respectfully requests this court to reverse the denial of his motion to suppress.
Thank you.
Thank you.
We'll hear from the state. Thank you.
May it please the court. Hello, my name is Jarrett McGowan. I'm an Associate Attorney General with the North Carolina Department of Justice. I am here arguing this case on behalf of the state. I had intended to address the arguments in a little bit different order, but I will follow the appellant's order of arguments for ease of understanding for the court. And so I will address the delay argument under Rodriguez first, then the separate Section 20 scope argument, and then lastly, the scope of consent argument. I do want to make clear, though, at the outset of that the state is not waiving its arguments on preservation of these arguments at the trial level. As you know, the defendant did not argue impermissible delay of the traffic stop at the trial level or the separate Section 20 scope argument.
Well, would you agree sort of fundamentally that if there is an unreasonable delay in the traffic stop, that would necessarily impact the voluntariness of the consent on that issue?
I would agree that it would impact the voluntariness in the abstract, but it is still the state's position. It's still the defendant's argument to make that specific challenge. Because the defendant didn't make that specific challenge here, the trial court made no findings of fact on how long the stop lasted or if Lieutenant Stone had additional reasonable suspicion to extend the stop, absent consent from the defendant. And Lieutenant Stone never went into those facts. And, as a consequence, that kind of deprives this court of maybe a fuller record before it on those issues. So the defendant argues
But isn't it the state's burden to establish the constitutionality of the stop?
it is the state's burden to prove consent. It is the state's burden to prove consent. However, to cede to defendant's argument that the defendant can just make a general challenge to consent and that preserves all arguments related to consent, not only scope of consent, but also whether there was an impermissible delay when consent was requested, that argument swallows up the whole adversarial process that our justice system is built on. If the defendant does not make that specific challenge at the trial level, once again, the trial court may not even get into that issue and not delve into and elicit testimony on those kind of issues. And therefore, a court of appeals, this reviewing court, may be deprived of an adequate record on that issue to make the best ruling. And so that is the state's position. Yes, the state does have the burden of proving consent, but only in the context of the defendant's specific challenge at the trial level. So defendant did make a scope of consent argument at the trial level, but did not elicit any testimony or make any argument about scope or impermissible delay of the traffic stop. So the state's position is those arguments are unpreserved. And also the Section 20 argument too was not made at trial level, so that argument is unpreserved. The defendant does ask for a Rule 2 suspension. However, it's the state's position that this is just not a case that is a good example or deserving of Rule 2 suspension. As set out in the state's argument, the arguments that defendant now brings for the first time on appeal have been litigated before. State v. Bullock, the Supreme Court opinion, most closely and squarely on these issues had already been issued at the time of the written motion to suppress that defendant filed and at the time of the hearing. So the defendant was not surprised or deprived of this argument. The cases where Rule 2 seems to be applied by this court generally involve a case or a situation where during the pendency of the appeal, some massive change in law happens. State v. McDougal, which is in the state's brief, is one such case. Also, the case that a defendant cited in the reply brief, State v. Campbell, is also another case where that happened. In State v. Campbell, the case went up to the NC Supreme Court, and the Supreme Court rendered an opinion that dramatically changed the legal landscape as to what entities are capable of owning property. The court said for the first time religious entities are capable of owning property.
And thank you.
Okay.
I didn't mean to take you too far
Okay.
afield from your arguments.
Well, I'll move on into the arguments then. The state is not seeing the preservation arguments. As to the impermissible delay of the traffic stop, in order for it to be a Rodriguez issue, as interpreted by our Supreme Court in Bullock, it has to measurably extend the stop. Here, you can see from the dash cam footage, admittedly, you can't hear the audio because the audio was not working that day, but you can see from the dash cam video what appears to be the interaction between the officer and Mr. Johnson. And at most, this request or this inquiry into did he have anything illegal, and this request for consent to search at most took 4 seconds, as I've interpreted the video. And in Bullock, the Supreme Court had to deal with not a request for consent to search, but other issues surrounding a traffic stop. Terry frisk, asking an individual out of the car, did those actions impermissibly extend the stop? And the court, with respect to the Terry frisk, said it did not violate the Fourth Amendment on 2 independent bases. And that's not me paraphrasing the Supreme Court. That is actually in the opinion. 2 independent bases. The Terry frisk was an officer safety measure, one, and officer safety measures are always part of the mission of the traffic stop. And 2, it did not measurably extend the traffic stop. That was an independent basis. So irregardless or should say regardless, of it being an officer safety measure or not, if it does not measurably extend the stop, in the Supreme Court's opinion, it is not a Rodriguez violation, not a Fourth Amendment violation. And the Terry frisk in that case took, I believe, 8 to 9 seconds. And if the Terry frisk that lasts 8 to 9 seconds doesn't impermissibly extend the traffic stop, neither does a request for consent and an inquiry into whether the defendant has anything illegal in their person lasting only at most 4 seconds. And
Does the actual time it took, is that really the calculation? Is there, I mean, do we have to do this with sort of that mathematical precision, or is it the fact that any detention beyond the scope of the traffic stop calls into account Fourth Amendment protections? Any detour from the mission of the stop?
Your Honor, and may I ask this of you, are you inquiring into still the delay issue, the duration?
That's right,
issue?
that's right.
It's the state's argument that
Well, I mean, you're saying it doesn't involve a Rodriguez type analysis, but are we really, part of the problem with Rodriguez, our analysis under it is we get so caught up on the time. A defendant will argue that, well, it took, as in the last case, 13 minutes to conduct this traffic stop. Here it states, well, it's just 4 seconds. But isn't any infringement, any seizure, any search that potentially detours from the actual mission of the stop, which here took seconds, the stop took seconds, doesn't that directly impact Fourth Amendment concerns?
no. I mean, as long as the stop is not impermissibly extended in time, then it's not a Fourth Amendment violation under Rodriguez. And conversely, in our court's interpretation of it under Bullock, also not a Fourth Amendment violation either. So it has to be a measurable extension of the stop for it to be a Fourth Amendment problem. And here, that was just not the case.
How long would it have taken? I mean, how long, what's the marker? What's the time marker?
That is a difficult question to answer. I mean, time is infinitely divisible. And so, how long it goes on before it becomes an impermissible delay, the court has not, I know of no court that has set a bright line rule. It's just for each court, the facts of the case, the circumstances of the case. I think that's the best approach because no two traffic stops are identical. And so it'll just have to be a question, a case-by-case analysis. But, Your Honor, I know of no bright line rule that says, 2 minutes is a Rodriguez violation, whereas a minute and 30 seconds is not, or a minute and 59 seconds is not.
Tell me a little bit about that. For example, the trooper sees the car driving down the road, driver's not wearing a seatbelt, makes the stop, walks up, says you're not wearing your seatbelt, here's your written warning, have a good day. Versus in this case, Lieutenant Stone sees, by testimony fleshed out on cross-examination, sees the defendant in this case in the parking lot of the convenience store with 2 straps hanging down, goes out onto the road, makes the stop, gets him out of the car for a seatbelt. Where's the consistency? Does Lieutenant Stone get his own set of time frames for conducting the seatbelt stop?
No, the state's not arguing that. There does have to be some systematic way for a reviewing court to determine if there's been an impermissible delay. State v. Bullock, which I would point to, is probably the most detailed analysis on the issue from the Supreme Court. And if it's an officer safety measure, then it's always part of the ordinary mission of the traffic stop. And therefore, as the defendant's counsel alluded to on her argument, Pennsylvania v. Mims and Maryland v. Wilson both say that that's an automatic officer safety measure to get the individual out of the stop. Out of the car, sorry. There is from Rodriguez, from Bullock, and from Campola, this is kind of like the trifecta of cases, on what tasks are ordinarily tied to the mission of a traffic stop and do not impermissibly delay it. Asking an individual out of the car, asking for a lawful Terry frisk or the time taken to do a lawful Terry frisk, asking an individual to get in the officer's car, deciding to cite or give a warning for the traffic infraction, checking for outstanding warrants against the driver, checking for the criminal records or criminal history of the driver and presumably the occupants, and also calling for backup if that is part of the agency's SOPs. Those are all, in Rodriguez and in Bullock and in Campola, all part of the ordinary mission of the traffic stop, and therefore the time taken to do those things does not impermissibly extend the seizure. And go ahead.
In this case, Lieutenant Stone approaches the vehicle, says, "I stopped you for your seatbelt. I'm going to give you a warning, assuming nothing else is wrong." I mean, he's kind of already accomplished the goal of the traffic stop being the seatbelt and given the warning at that point. So we get
Well-
beyond that. So tell me about that.
He hasn't accomplished the mission of the traffic stop yet because he's not gone through the rest of the routine missions that are related to the traffic stop, even from Rodriguez, and that is checking license, registration, checking for outstanding warrants against the driver. Those are always part of the ordinary traffic stop. And so he says,
Those are permissible.
yes, those are,
Those are not always.
oh, yes.
I just gave you the example of the trooper walking up saying, "Hey, put your seatbelt on, have a good day."
Yeah, Your Honor, I'll rephrase my statement. It's all permissible actions in a traffic stop. And so he said, I'm going to give you a warning assuming nothing else is wrong. So that implies that he was going to do those other checks at some point. So the traffic stop had not yet been completed in this case. And him asking for Mr. Johnson to get out of the car, that's always permissible. That is automatic per a lawful traffic stop, per Pennsylvania v. Mims, per Maryland v. Wilson. And so that did not add time to the stop. And then the only thing that the defendant really focuses on here is the inquiry, do you have anything illegal in your person? And then the request for consent. Well, even if those were not part of the ordinary mission of the traffic stop, they did not measurably extend the traffic stop so as to violate the Fourth Amendment. They took it at most 4 seconds here. And then the defendant does argue that we have to look at the whole time, the 26 seconds it took to do the search. However, once the individual has given consent, then, it is only logical that if they give consent for the action, they also give consent for the time necessary to perform the action. I know of no other construction that makes logical sense.
Does the state concede that the search in this case was not a Terry frisk?
Yes. This was in the pockets. Terry frisk is normally pat down in the outer layer of the person's clothing. So it was not a Terry frisk, it was more than that. But the state's position, it was consensual at that point. And obviously we'll get to that in the third argument. And so there was no impermissible delay here from the state's position. Also, defendant cites the State v. Parker, which does have some language in it that says that in order for an officer to request consent, it has to be additional reasonable suspicion. This court cites the State v. McClendon for that argument, which is in North Carolina Supreme Court case, and I have read it, ad nauseum, and I cannot find anything in that opinion that supports that proposition. The court talks about extending the time, and has to be a permissible duration, but State v. McClendon was not a consent case. In fact, in that case, the officer asked for consent, it was denied, and they ended up calling a canine out. And so the court focused on the time between the warning ticket and getting the canine on scene. That was the time that the court focused on, and it did not even go into, issue of did the request for consent by itself impermissibly extend the stop. And so it appears to me that State v. Parker may have misinterpreted State v. McClendon. Also, as to defendant's next argument, which I'll segue into, the Section 20 argument, there's an Alaska case that the defendant cites for his proposition that also references State v. McClendon and State v. Parker for the proposition that some courts have said that their state constitutions provide additional protections than the Fourth Amendment, and that their constitutions prohibit questioning on anything outside the scope of a traffic stop, even if there's no delay. But once again, I can find nothing in State v. McClendon that even gets anywhere near that. But as to the defendant's second argument, the Article 2, Section 20 argument, there's just no basis in either the text of the General Warrants Clause or in the prior jurisprudence of the state to expand the protections afforded by the General Warrants Clause and to interpret it as affording more than the Fourth Amendment allows, or I should say, providing more protections than the Fourth Amendment provides. We do have one case, State v. Carter, that says the good faith exception doesn't apply to our Constitution, and it does apply to the Fourth Amendment. But as far as I can tell, that is the only precedent in this state where our courts have interpreted Article 1, Section 20 at variance with the Fourth Amendment. We have various other cases, Supreme Court cases as well, that have said that the protections afforded by Article 1, Section 20 are coextensive with the protections offered by the Fourth Amendment. And so if the Fourth Amendment allows inquiry, that is not related to the scope of the traffic stop, but that doesn't impermissibly extend it, then so does our General Warrants Clause, Article 1, Section 20. The defendant does point to some other states that have interpreted their constitutions differently, but those are different constitutional provisions, and they also have different jurisprudential histories. For instance, the Alaska case that found its constitution offered more protections did so because the actual language is broader than the Fourth Amendment. It protects other property, whereas the Fourth Amendment doesn't. And the Alaskan state, citizens of Alaska, had amended their constitution to put an explicit guarantee of privacy in it. And so that was the court's rationale for saying that their Fourth Amendment equivalent provided additional protections. But we have no such same jurisprudential history here in North Carolina that would, give rise to an interpretation of the General Warrants Clause for which the defendant advocates. Article 1, Section 20 is coextensive with the Fourth Amendment and allows inquiry, even if it may be unrelated to the scope of the traffic stop, as long as it does not impermissibly delay the traffic stop, which it did not here. That's the state's position. As to the defendant's last argument, the scope of consent argument. This was, once again, the only argument that was preserved for appellate review. The other argument that was argued at the trial level was the reasonable suspicion for the stop. That's been waived on appeal per the defendant in the defendant's initial brief. And the scope of consent argument, it is, and I'll agree with the defendant on this point, it's an objective test. The court looks at what would a reasonable person have understood the exchange between the officer and the individual to mean. Here, defendant's point that he testified at the motion to suppress that he understood the request to be just a request for a pat-down, that's irrelevant to the test. It's an objective test for that very reason, so that the officer, neither the officer nor the individual can impermissibly manipulate the court's review by saying, their subjective expectation is something different.
Well, what about the argument that the trial court did not resolve that sort of ultimate question of fact in its ruling?
Your Honor, I disagree with that contention. The court made oral findings of fact. Oral findings of fact are permissible, maybe not the best practice, but they are permissible per State v. Bartlett. And the court was explicit it was making oral findings of fact, too, in its section of the transcript. I think either the defense counsel or the prosecutor asked for written findings of fact, and the trial judge says, I think the Court of Appeals is okay with.
I'll tell you what the court said.
Yes.
It says, I understand the Court of Appeals is fine with an oral argument on the record.
Yes.
With an oral order on the record. If you wish to prepare an order, I'll be glad to sign it. I'm not sure that that's an accurate statement of how the Court of Appeals views oral orders versus written orders, but I'll defer to my colleagues.
I understand that maybe the Court of Appeals is not pleased with the oral findings of fact, but they do appear to be adequate under the law.
Well, I think the more direct question is in the oral findings of fact, the trial court finds the officer asked, "Can I search you?" The defendant gave consent to search, and without really addressing specifically the scope of consent. There's just request for a search and consent to some search. So I guess the question is, are we to infer from that the trial court was making a finding, an ultimate finding of fact that the consent to search was in fact as broad as, it was objectively reasonable that the consent to search covered?
Your Honor, sorry. Your Honor, yes, the court's finding on whatever its issues can be inferred from its finding, and that's kind of a finding / conclusion of law, that the defendant gave consent to search. And it can also be inferred from its ultimate ruling that defendant's motion to suppress should be denied. And so, even though, yes, maybe it would have been better, it would have been nicer if the court had, specifically set out a separate finding that a reasonable person would have understood that request for to search to be a request for a full search of the person. Even though maybe it would have been better to do that, the findings are adequate, and that this court can infer that the court made the correct finding and conclusion from its ultimate ruling and from its oral finding of fact conclusion that the defendant gave consent. Because that was the specific challenge that defendant put before it at the motion to suppress hearing. So it's the state's position that the oral findings of fact, while not the best thing, are adequate for appellate review. And so the test is an objective one, that the court asks how would a reasonable person understand the exchange between the officer and the individual. The court plunks down that reasonable person in the situation. I like to think of it kind of as a witness to the interaction, and ask that reasonable person what would they understand the exchange to mean. So the court looks at a totality of the circumstances. Once again, that was not specifically addressed in the oral findings, but that can be inferred from the ruling here. Here, the kind of totality of the circumstances were the wording or phrasing of the request by the officer. I think also his prior inquiry to the defendant, do you have anything illegal on your person? And then the defendant's gesture in response. There's some discrepancy in the evidence on that fact, whether he said yes. Lieutenant Stone testified he said yes. He testified that he raised his shirt in response. You can see on the dash cam that what he actually does is kind of do this right here. He gives the end of that, the nub of that argument is, regardless of the form in which he gave consent, he gave an affirmative response to the officer's request to search his person. And consent can be given in this state in writing, verbally, non-verbally. And we have cases to that effect, State v. Graham, State v. Harper. This case appears to be very close to State v. Graham. State v. Graham, the officer asked for consent to search the individual person, and the individual raised his hands away from his body, which is what appears that the defendant did here on the dash cam video. And so consent can be given non-verbally, even though the court does not make a specific finding on how the defendant responded. The defendant is only required to do a finding of fact on material conflicts in evidence. And here, because the law says that consent can be given in any format, there was no material conflict in evidence here, regardless of the way that he gave consent and responded, because that doesn't change the outcome.
But isn't that the material conflict in this case? Basically, the sort of the scope of the intent, when he sort of steps back and kind of points at his sweater and puts his hands up, says, sure. Like, what is the material conflict is what is being consented to there, and doesn't the state have that burden?
The state does have the burden of proving this consent and addressing the defendant's challenge as to consent. Here, the scope that he gave consent to a full service person. But here, the state has met its burden. And, regardless of which way he responded, raising his shirt, raising his hands away from his body, or saying yes, that is an affirmative response to the Lieutenant Stone's request, can I search you? Can I search your person? Or I think the courts found, can I search you, was the way he phrased it. And I cannot see that any one of these responses is somehow limiting, in relative to the officer's request. That somehow one of these responses limits, if consent was given, which it was, limits the officer's scope where the officer could search. So that is my response, Your Honor, to that question. regardless of the way that he responded, he gave affirmative consent, and that affirmative consent included a full search of his person, not just a pat down or Terry frisk. Also, another thing the courts look at is the individual's actions when the challenge search is performed. And so the courts do look at the reaction by the individual when the officer does what he or she allegedly requested to do. We have cases on that as well, many cases. State v. Stone, State v. Neal are the primary cases. And here, when the officer requested consent to search, when the defendant gave his affirmative response, you can see the officer go into the search of his pockets, and the defendant appears thoroughly unperturbed or shocked. He does not appear surprised, shocked, or concerned about what Lieutenant Stone is doing. You can't see his face throughout the entire thing, but you can see it from most of the dash cam, and he does not appear to evince any shock or surprise when Lieutenant Stone goes in his pockets. And I think at one point when the officer's behind him, he's smoking a cigarette casually, and does not appear to understand Lieutenant Stone's actions as outside of the consent that he gave.
But isn't that really exactly how, as a court system, we would want the defendant to react? Just simply, if the search is going too far, rather than escalate the situation by forcefully resisting, wouldn't we prefer to simply allow the illegal search, let's sort it out in court, and shouldn't the defendant have the right to be able to resort to the courts to rather than self-help in that situation to undo the effects of what is alleged to be an illegal search?
Your Honor, of course the defendant should have recourse to the courts, but the defendant merely, exclaiming, "Hey, what are you doing, officer?" or "How are you? What are you doing?" I don't think that is necessarily escalating the situation. We do have cases where that has occurred, and so apparently defendants, some defendants understand they can do that, and State v. Duncan was one of them, where the officer went to a Terry frisk, and the individual said, hey, I don't give you permission to do that. What are you doing? This is not a Terry frisk, man. Something to that effect. I'm paraphrasing, obviously. Inquiring into their reaction is given the case law, of course, I think certainly permissible and one of the relevant factors that a court considers when reviewing the scope of consent. Here, the defendant was very casual, unperturbed, and so it appears that his subjective understanding of the request in the moment was that Lieutenant Stone was in the scope of what he had requested the defendant to do. And so the court, looking at all those factors, what was said, what was the inquiry, what was the wording of the request.
Well, but that was also, and I know you're running short of time, but that request is also in the context, apparently based on the evidence, of the officer retaining the driver's license or the ID and saying, hey, I'm going to let you go if there's nothing else wrong. I mean, there's a coercive element there. Would you concede that? Whether it's impermissible or not, I don't know, but would you concede
the situation has changed from a purely consensual encounter on the street. Yes, I would agree to that. And the defendant's custodial status is one of the factors the court looks at in determining if consent was voluntary. But the fact that the defendant was detained or even arrested and in custody does not preclude a court from finding that the consent given was voluntary. We have cases in the state where the defendant was handcuffed. In the State v. Wright, defendant was handcuffed, and the officer asked for consent to search the vehicle, and the individual said, go ahead. The court found it was voluntary. We have a case where the individual had already been formally arrested and handcuffed, so you were under arrest, definitely in custody, and the officers asked for requested consent to search his room, and he said yes, and they searched and found items that incriminated him in a burglary. So yes, Your Honor, while the custodial status is relevant to the issue of scope of consent, and whether it's voluntary, the fact that the defendant has been detained does not preclude the court from finding that he gave voluntary consent, and that the scope of that consent included a full search of his person.
And we'll give you a few moments to conclude.
Yes, Your Honor, for all of the aforementioned reasons, the state would argue that the court affirm the trial court's denial of the defendant's motion to suppress. Thank you very much.
Thank you, counsel. Are you ready for rebuttal?
Thank you, Your Honor. At the risk of confusing the court, I'm going to address scope first and then respond to the Fourth Amendment argument made by the state. First, as to Judge Hampson's question, whether or not the court can infer a finding from the trial court's ruling that the search was within the scope of consent, I would answer that question that the court cannot make that inference here because of the way the trial court ruled. It ruled with an alternative argument or an alternative rationale that said even if the scope was limited to a Terry frisk, it doesn't matter because of plain feel. And that alternate basis kind of undermines any reliance or inference on the court's ultimate ruling as inferring that the court made a specific finding about the scope of consent. Further, as to the state's argument that really focuses on one single factor, Mr. Johnson's reaction to the search that was conducted, I just would reiterate that is an especially weak factor for two reasons. One, because the test is an objective one, and you're looking at Mr. Johnson's subjective reaction after the scope has already been violated. And two, because in the context of traffic stops and the long history of racial issues surrounding those, this court has held that those considerations can factor into how the court analyzes somebody's reaction and what it makes of it. And in this case, Mr. Johnson's failure to object when he's being searched in this way you can't read too much into that, I would argue.
You can't, that he didn't assert his rights? We can't read too much into that? Is that what you're saying?
I'm saying that it's one factor among many, and it's a weak one. As to the Fourth Amendment issue, the state is really asking this court to overturn State versus Parker, and in re civil penalty prevents this court from doing that. The state's argument also essentially asks to expand Bullock. Bullock said that the time used for a frisk, the court in Bullock said that the stop wasn't unlawfully extended because the frisk that occurred was related to the traffic stop mission and it was brief. It was 8 to 9 seconds. This court in State versus Duncan cabined Bullock to its facts and said, yes, a frisk is related to the traffic stop mission, but a full search into pockets is not. And that controls here in this case. It also, in Duncan, this court said that 8 or 9 seconds is markedly different from, in that case, it was a 34-second search. I would say that the search that occurred here, which was 3 times the length of the one that occurred in Bullock, also does not fit within Bullock's rationale. In Rodriguez, the United
So Duncan kind of, I mean, there are some distinguishing facts in Duncan. I mean, there was some discussion as to consent to the Terry frisk, or whether it was just compliance, and whether, but the officer also made very clear that at some point he stopped the traffic investigation and started a drug investigation. We don't really have that here because of the consent issue, which wasn't necessarily at issue in Duncan.
Well, I don't think that the state contends that the request for consent to search was part of the traffic stop mission. The state's argument is that it just didn't take very long to ask. And once Stone got consent, he could go off on his merry way down the detour. And I just think the court's rule, the case law from State versus Parker precludes that argument.
And I'll give you a few more moments just to wrap up
Okay.
and conclude.
Okay. 14 years ago, this court decided State versus Parker. It unequivocally held that requests to search, like the one made here, are unconstitutional. This case makes clear that Parker is being ignored or its validity questioned. It is of supreme importance to the privacy interests of North Carolinians, and especially to people of color, that this court reaffirm Parker and reverse the trial court.
Thank you. Well, thank you to both counsel for your excellent arguments today. I really appreciate both the briefing and the arguments. No further matters being before the court. This matter will be submitted, and we'll adjourn this session of court. Mr. Soar.
All rise. The session of the North Carolina Court of Appeals is now adjourned. Thank you.